Alright guys, this is Kelly of Rojo Chief Clothing, and here we're going to talk about Aboriginal sovereignty and imperial claims. Okay, it says by Brian Slattery, it is commonly assumed that indigenous American nations had neither sovereignty in international law nor title to their territories when Europeans first arrived. North America was legally vacant, and European powers could gain title to it simply by discovery, symbolic acts, occupation, or treaties amongst themselves. It says it follows on this view that current indigenous claims to internal sovereignty or a third order of government have no historical basis. It says this paper argues that this viewpoint is misguided and cannot be justified either by reference to positive international law or basic principles of justice. It says the author view of that indigenous American nations had exclusive title to their territories at the time of European contact and participated actively in the formation of Canada and the United States. This fact requires us to rewrite our constitutional histories and reconsider the current status of indigenous American nations. In other words, what it sounds like is that they tried to lie and say that indigenous nations, the American Indians, that they don't have any standing in law as far as having sovereignty and ownership over their territories when they absolutely do. Okay, so that's that. And then I'm gonna move on over to the Constitution of the United States. Okay, so it says here, formally addressed in the United States Constitution, tribal sovereignty was addressed in the U.S. Constitution and adopted in 1788. The Commerce Clause, Article 1, Section 8, Clause 3, read that Congress had the power to regulate commerce with foreign nations and the Indian tribes. Thereby, Native American tribes, which is supposed to be American Indian tribes, who signed treaties with the United States are deemed sovereign, independent nations by the federal government. It says the Chickasaws Treaty of Hopewell, signed 1786, formally acknowledged the Chickasaw Nation's tribal sovereignty that is still recognized today. Okay? Alright, so I'm going to leave it there for that. Okay, now this is a screenshot that I took from Wikipedia concerning, Indian treaties and stuff. Here it says the United States Constitution mentions Native Americans tribes 3 times. It says Article 1, Section 2, Clause 3 states that representatives and direct taxes shall be apportioned among the several states, excluding Indians not taxed. So in other words, that it basically said in the Constitution that that Indians were supposed to be excluded from being taxed, of course, because it's their land and they're sovereign. So why would a sovereign be taxed, right? So it says, according to the stories, commentaries on the U.S. Constitution, there were Indians also in several and probably in most of the states at that period who were not treated as citizens and yet who did not form a part of independent communities or tribes, exercising general sovereignty and powers of government within the boundaries of the states. And then it says Article 1, Section 8 of the Constitution states that Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes, determining that Indian tribes were separate from the federal government, the states, and foreign nations. So basically, that Indian tribes were separate from the states, we're separate from the federal government, and we're separate from foreign nations as well. Okay, so we're our own people, we're our own government, totally separate from the foreign nations, the federal government, and all the other states that exist within the United States. Okay, so these are some cases. Johnson versus McIntosh, 1823. It says holding that private citizens could not purchase lands from Native Americans. So basically, all these people that's saying that they have land or they own land, well, according to this case law, that private people, they're not able to buy land from American Indians, according to that. Okay, then you go further and look at the Cherokee Nation versus Georgia, 1831. It says holding the Cherokee Nation dependent with a relationship to the United States like that of a ward to its guardian. Then you have Rochester versus Georgia. It's in 1832, a year later. It says which laid out the relationship between tribes and the state and federal government, stating that the federal government was the sole authority to deal with Indian nations. Okay? And then here, when you look down, it says Indian Appropriations Act 1871 had two significant sections. First, the act ended the United States recognition of additional Native American tribes or independent nations. So the United States, they don't recognize any more American Indian tribes or nations. According to that, that's how I take it. That's how I take this particular act. And then it says, and prohibited additional treaties. It says, thus it required the federal government to no longer interact with various tribes through treaties, but rather through statutes. Now that's something that's very important to know, All right, so that's that. And then here you see in the Indian Appropriations Act of 1871, then they tried to lie and say that Indian nations were not nations. But previously, they admitted that indigenous nations, that they have sovereignty on their territories and that they have title over their territories. But anyways, it says that hereby no Indian nation or tribe within the territory of the United States shall be acknowledged or recognized as an independent nation, tribe, or power with whom the United States may contract by treaty. Provided further that nothing herein contained shall be construed to invalidate or impair the obligation of any treaty theretofore lawfully made and ratified with any such Indian tribe or nation. So to me, it seemed like they tried to renege or try to get rid of or ignore the fact that the United States signed treaties with the Indian nations and tried to say that they weren't, sovereign, independent nations, even though indeed they are. Okay, so right here it says fauna. It says fauna assists the efforts of its members, tribes, and nations in bringing to light more than 600 years of international and national archive history to reveal hidden truths about the true diverse cultures and heritage of America's Aboriginal populations. With the historical knowledge of laws and treaties, fauna provides private confidential support and assistance for member tribes and nations, which include but are not limited to sharing of information, classes, and instruction of law and indigenous judicial processes, where members gain greater insight pertaining to their privileges, immunities, and rights under international, Aboriginal, and American Indian law. Fauna also assists member tribes and nations in researching and filing claims for violations, land rights, rights to monies owed from treaties, corporate identity theft, housing fraud, and international human rights violations. And also include violations, and then it kept going, but I didn't capture that part. But anyways, so basically there's 3 different type of laws that they're talking about that the Indian nations have. We have international rights, we have Aboriginal rights, and then you have the American Indian law. So it's 3 different things that we have, the different laws that we have to look at. We got international law, we got to look at Aboriginal law, and American Indian law that we have to look at when it comes to our rights. And also, what they were saying here, they were talking about land rights and monies owed from treaties. Now, that's important because of the fact that in the Constitution, and also according to the book, when it was talking about Aboriginal sovereignty, it was basically saying that the indigenous nations, that they are sovereign and that they have title to their territories, you know. But yet the United States tried to lie and say that the Indian nations were not independent nations, and tried to say that they were dependent nations. And then also try to say the same thing in a case pertaining to the Cherokee Indians by trying to say that they were dependent nations, which to me, that doesn't make sense, you know, because how could you be a dependent nation when you signed a treaty with another nation? So that means that you had to have been sovereign in order for you to sign that contract with another nation, you know. But anyway, so tell me what you think about this. Please like, share, and subscribe. I'm out.